Vicarious liability is where one person is held liable for the torts of another, even though the person did commit the act itself. It is therefore a form of strict liability. The most common form of vicarious liability is when employers are held liable for the torts of their employees that are committed during the course of employment. Many different theories have been advanced to justify the doctrine of vicarious liability, but the most accepted justifications are the benefit and burden principle. The employer has established a business and derives the economic benefits of commercial success. The employer ought to therefore be liable for damages caused by the business. The employer has created a risk and should be answerable if the risk materializes. The employer is in the best position to know or to find out the nature and the cost of the accidents associated with the business and to take insurance against these risks. The employer has responsibility for ensuring that its employees are effectively trained to carry out the work safely. The employer is more likely to take staff training and supervise seriously. The principles of vicarious liability means that the employer is more likely to be careful in selecting employees and to provide incentives to encourage them to take care. The effect of the employer bearing the cost of insurance liability is to spread the loss, as the extra cost can be passed on to the public in the form of higher prices. The last in hand is the deep pocket argument, which is based on the fact that an employer is better able to pay compensation and is more likely to have liability insurance, and this stems from the case of JGE versus Portsmouth. The employee who committed the wrong remains liable. Vicarious liability is a form of secondary liability. For reasons of policy, the courts have considered it desirable to give claimants injured as the result of an employee's tort an action against the employer as well. To succeed in the claim based on vicarious liability, the claimant has to establish that the alleged tortfeasor was an employee, the employee committed a tort. Number 3, the employee committed the tort in the course of employment. One problem in particular the courts have had in determining what constitutes the classification of an employee. This is partly due to there being so many different employment relationships. One of the early tests used to determine the issue was the control test, which asked whether the master had the right to control what was done and the way it was done. However, this test was seen to be inappropriate, except perhaps in cases of borrowed workers, as in Merseyside Docks and Harbour. The courts then recognized that a single test was not enough to determine the employment status, so the courts developed a multiple test in Ready Mixed Concrete versus Minister of Pensions. McKenna J stated that a contract for service existed if the following 3 conditions were present. Number 1, the servant agrees that in consideration for wages and other remuneration, he will provide his own work and skills in the performance of some service for his master. Number 2, the servant agrees expressly or implied that in performance of that service he will be subject to others' control in a sufficient degree to make that other master. Number 3 is that the other provisions of the contract are consistent with it being a contract of service. Furthermore, McKenna and Jace described control as including the power of deciding the thing to be done in the way, the means, the time, and the place. Pondering upon the issue of independent contractors in Barclays Bank versus various claimants 2018, the Court of Appeal doubted the survival of independent contractors' defense. In subsequent case law, another test known as the Salmon test came to light. However, this restrictive test was largely improved after the decision of the House of Lords in the controversial case of Lister versus Hesley Hall, where a warden sexually abused young boys at the home where he was employed to look after them. The House of Lords held in this case that an employee would be vicarious liable for an employee's tort if there was a close connection with the employment. In conclusion, the concept of vicarious liability is a very complex issue, as it is torn between trying to protect the rights of the victim to gain sufficient compensation and trying to protect the employer from being overburdened by their employees. Although it goes against the principle that wrongdoers should pay for their own act, the doctrine of vicarious liability seems appropriate as it does serve a useful purpose, that is, it contributes to the maintenance of safety standards and it enables the victims of negligence by employees to be reasonably certain will be in a position to pay that compensation.